This is our penultimate panel, the SEC and cybersecurity, rulemaking, enforcement, and coordination with the DOJ and other regulators. Our moderator for today's panel is Rob Cohen, who is a partner at Davis Polk here in Washington, D.C. Rob previously served for 15 years in the SEC's Division of Enforcement, including as co-chief of the Market Abuse Unit and as the first ever chief of the SEC's Cyber Unit. Next to Rob is Olivia Choe, who is a partner at Milbank, also here in D.C. She has nearly 15 years of experience as a government trial attorney, supervisor, and senior enforcement official, including serving as the chief litigation counsel for the SEC, and before that, as a criminal prosecutor in the Department of Justice. Next to Olivia is J.R. Drabick, who has joined us all the way from Boston, where he is counsel in Ropes and Gray's Litigation and Enforcement Practice Group. There he advises clients across highly regulated industries such as financial services, investment advisory, healthcare, life sciences, and technology. He is a former federal prosecutor and SEC enforcement attorney. Next to J.R. is Jonathan Hecht, who is a partner at Goodwin here in D.C. Jonathan spent more than a decade in the SEC's Division of Enforcement, including as Assistant Chief Counsel in the SEC Enforcement Division's Office of Chief Counsel and the Enforcement Division's Acting Co-Chief Counsel. And finally, we have Marlier, who is a partner at Morrison and Foerster in New York. She is a member of the firm's Investigations and White Collar Defense Group and co-chairs both its FinTech and Securities enforcement practices. Before joining Morrison and Foerster in 2020, Haima spent nearly a decade in the SEC's Division of Enforcement, where she served as senior trial counsel. With that, Rob, it's up to you.
You sure we have time left? That's a lot of introduction.
Got a lot of impressive stuff.
Excellent, thanks. So we have a lot to talk about today. I'm sure people have seen these surveys of what keeps CEOs or board directors awake at night worrying, and cybersecurity is always on the top of the list. So it's a great topic, and a lot's been happening recently. So starting off, the specialized unit at the SEC's Enforcement Division that focuses on cybersecurity has gone through several changes in its long and illustrious history. JR, do you want to talk about the most recent change? What's the current focus?
Yeah, happy to. So, as folks probably know, earlier this year in February, the crypto unit was rebranded back to a cyber unit, the Cyber and Emerging Technologies unit. The one thing we noticed was that the press release seemed to be a pretty clear cut and paste job from Rob when he wrote it the first time around for the cyber unit. And I think a theme is that it's back to basics, right? And we've heard this on a number of the panels today, back to traditional fraud, back to looking at the types of things the SEC has brought in years past and not pushing the boundaries too much. And I think what you see when you look at those priorities is back to basics and looking at fraud and looking at it just when there's a technology bent to it, right? When there's something new and emerging about the subject matter, but not necessarily the nature of the underlying conduct. And so you're looking at things like disclosure fraud, things like AI washing. You're looking at use of social media, right? The SEC just had a trial win in a scalping case not a few weeks ago where individual uses social media to pump up a stock that they're looking to sell. Those types of cases where same fraud principles that we've always seen, just using new technology. One of the things I think that will be interesting, right, and there was an AI panel, and one of the things with AI that I think will be interesting is not just AI washing, but how firms might start to integrate AI into their investment decision making, and some of the pitfalls you might see there in terms of we can't really necessarily always explain how AI does what it does. And one of the things that we're starting to see in the news more and more is that AI will be deceptive, will try to play to what it thinks the person who's putting in the prompt wants. And on this score, one of the things I always appreciate is when ChatGPT says to me, good question, excellent question. And I think one of the things we'll see is that could be on the forefront for something like the cyber unit is, are firms using AI in a way that the AI is causing them to run into problems that they might not even foresee and be able to address?
Great, thanks. So that's those are the people who are focusing on this at the SEC, if and when the SEC reopens. Let's talk about the rules. So when it comes to cybersecurity, there are some rules in place for different parts of the industry. Typically start with Reg SP, Reg SID goes with it. So Reg SP has been on the books for a while. There's an amendment about to come online, and there were some proposals in the last administration to really blow out the rule. Those are probably dead, I would think, but JR, I just want to give like an overview of the rules that apply to broker-dealers and investment advisors.
Yeah, 100%. So as Rob noted, there's an amended Reg SP that's about to go into effect for very large firms, and then in December, and then for smaller firms, broker-dealers, investment advisors in the middle of 2026. It's essentially a backwards-looking rule in that it requires firms to have in place incident response plans so that they can react to any cybersecurity event that might befall them. Includes specific requirements about customer notice within a certain amount of time, 30 days. And I think from an enforcement perspective, one of the sort of potentially fertile grounds for future enforcement around the amended rules is with respect to supervision of service providers. At least from what I've seen, oftentimes, firms get attacked day in and day out, and if they have good cybersecurity protocols, hopefully they can withstand those attacks. Their service providers aren't always quite as strong as they are. And what the amended Reg SP rules require is that the firm have written policies and procedures for supervision of those service providers, and also that the service providers have to provide notice within 72 hours of any breach that they suffer that impacts the firm's PII or customer PII. And I think that's a potential weak spot that firms will need to pay attention to, and potentially, because the thing is with breaches, at least in my experience, is the regulators swoop in after the firm has been attacked and suffered the breach. And it doesn't really matter necessarily how good the firm's protocols were. At that point, there's been a breach, maybe there's been exfiltration, there's a sense of harm potentially to customers, and so it's very easy to second guess. And so I think in that space where you're dealing with lots of vendors, that could be a potential weakness.
Great. And I think the amendment that's about to come online is sort of like the latest step in a progression over time of the SEC more directly regulating firms' cybersecurity practices. So disclosure has always been an issue. Protecting information has been part of this rule for a long time, but increasingly we've seen it in exams and investigations. It started with Reg SCI, focused on like the exchanges, now in Reg SP. The SEC is increasingly trying to take direct responsibility for regulating things like incident response, which is not a traditional area of SEC expertise. Okay, so those are the rules at a high level for investment advisors, broker-dealers. Really a topic where we could chat for a long time is public company disclosures. I still kind of call them new rules, or not brand new, but we've had a year or two now of the new disclosure rules for public companies. John, can you give an overview? And then I think we're going to talk about, now that we've been operating for a couple of years under these rules, what are the issues we've seen emerge, both in our practices and filings, et cetera. So can you just remind people of what these rules are?
Yeah, happy to. Thanks, Rob. So the rules are a couple of years old, and so I won't spend a lot of time on them, but they're still worth focusing on a couple of key points because they provide key guideposts for us, not just on difficult disclosure decisions that we're all advising clients on, but on potential enforcement risks going forward, particularly in this administration. And so the rule really has, from a public company disclosure perspective, two key components. It's the annual disclosure requirement regarding cybersecurity risk management and the 8K obligations for the announcement of material cybersecurity incidents. And so just taking each in turn, with regard to the annual disclosure, the rule under item 106 of Reg SK requires registrants to describe their processes, if they have them, for assessing and managing material cybersecurity risks, and whether those risks, including from past incidents, materially affected or are reasonably likely to materially affect the reporting company. The rule also requires registrants to describe their board's oversight of risks from cybersecurity threats, and management's role and expertise in assessing and managing material risks from cybersecurity threats. With regard to 8K, item 1.05 of Form 8K requires registrants to disclose any cybersecurity incident that it determines to be material and describe the material aspects of the nature, scope, and timing of the incident, as well as the material impact or the reasonably likely material impact of the incident on the company's financial condition or results of operations. And so some of the key aspects of this is timing, which I think we'll get into in a bit.
Yeah, so let's go there, and the whole panelist, everyone practices in this area, so feel free to share. What are the pain points that you've seen so far in client interactions, client advice, the sort of tougher aspect of making these disclosure decisions? What are the hard parts?
Well, in my experience, people know enough to know that they're on the clock. As soon as a cybersecurity incident occurs, there's incident plans that need to kick into gear and move forward, and one of the key aspects of that is the disclosure. But from a timing perspective, under the rule, registrants have to make that materiality determination without unreasonable delay following the discovery. Once that determination is made, then the clock really kicks in. You have 4 business days to make the 8K disclosure.
And so, in some sense, the easier time period is once you've decided it's material, you have 4 days. The harder time period is the process of deciding whether or not it's material and how much time do you have to do that. So you mentioned without unreasonable delay. I know we were talking about this beforehand. That is one of the harder parts of this. What's our time period for making this decision? So without unreasonable delay, that's a change from the original proposal, right?
Right. From the proposing release, the language was as soon as reasonably practicable, which is really a different kind of standard. There was a lot of commentary on that aspect of the proposing release, and ultimately the Commission made the determination in the adopting release to move to this unreasonable delay standard. And it's not a defined term in the rule, but the Commission did helpfully give some guidance on what it would view to be an unreasonable delay, which I think we talk to our clients about all the time in terms of, okay, what does that look like? And so they gave a couple of examples of what the Commission's expectation would be for making a fast determination. For example, if the threat actor had accessed systems that were, quote unquote, the crown jewels of the company, or had exfiltrated a large amount of very sensitive information on customers or clients. I think the Commission's expectation as it was promulgating the rule was that even without perfect information, they're still conducting an investigation, they're doing the assessment, that's probably enough to trigger the materiality determination, that it is material. As opposed to the flip side of what would actually unreasonable delay look like. Say you have a board committee that's required to make the materiality determination and they're going to meet on Friday, but you don't want them to do that yet because you want to push the determination until the following week. The Commission made very clear in the adopting release that that would be viewed as an unreasonable delay.
Right. So what have we all seen in terms of clients dealing in reality, in real life events with this rule? And I'll ask this for the whole panel. Don't cancel a board meeting to avoid making a decision. That's probably pretty easy. But cybersecurity inherently is fast moving, a lot of uncertainty. You could be learning things weeks or months after you first learn of the event. I'm happy to share, but does anyone on the panel want to talk about what they've seen with clients wrestle with this?
Yeah, I think we're actually in a period of more certainty now than we were perhaps 18 months ago. Just anecdotally, what we were seeing a lot of was clients feeling very rushed in conducting their investigations. Clients often wondering, well, should we just make an 8K filing? I'm not sure whether this is material, but wouldn't it be better to just make a disclosure so that no one could later say, we didn't make a disclosure? I think the Eric Girding guidance that came out from CorpFin is really helpful, which basically in plain English says, don't disclose it as a material incident if you don't think it's a material incident. There's no need to file an 8K. So I'm interested in other people's thoughts, but I think this has gotten smoother and we've gotten away from some of the uncertainty and in some cases like panic over what to do and really rush what, as John said, is like a very complicated and technical investigation.
Yeah, and clients feeling under the gun, I think, is absolutely, accurate. Certainly what we've seen. On incident response, there's like this laundry list of state and, if you're outside the U.S., foreign disclosure regimes where you have to make really quick disclosures to impacted customers, impacted clients, privacy regulators. And a lot of times this just gets added to the list of things to check off, all the disclosures. But it's a different type of disclosure, right? You have time, whether something's material is a different threshold than these others. So let me give a hypothetical that we used in a tabletop very recently. Let's say your client calls you, it's a large public company, they've had a ransomware event, systems are shut down, employees can't access their computers, the public can't access the website, customers can't place orders. The systems went down this morning. You're now in like a 2 p.m. meeting of whether it's a disclosure committee or a lot of companies have like a precursor to the disclosure committee. And people around the table are saying, this is terrible. Everything's down, employees can't work. So how do you look at that under the rules? Oh, all right, well, let's get an 8K filed, or is it not that simple? Anyone?
So I think in the initial run-up to the rule and then following the effective dates of the rule, I think the reaction to that hypothetical would have been just as you described, which is let's file an 8K. There are risks associated with that. One, you don't have the full picture at that point. You're still making the assessments. So if you make the 8K, are you essentially obligating yourself to do future 8Ks because the rule does require amendments or updates as additional information is being made? I think now with the benefit of 18 months of practice here, I think that my guidance often is let's take a beat. Let's do what we can under our policies and procedures to make the assessment. Let's begin our incident response plan. Understand what we can about the nature, scope, and timing of the incident, and make a decision per our policies, and then start the clock, because that's really the trigger point. Follow your policies, make the assessment, and then you know whether first you have to make the disclosure, and then following that, even more importantly, what the disclosure is actually going to say.
Yeah.
And I was going to say, I think that the settling in that you're referring to, you can see in the difference in the number of filings. Just taking a non-scientific peek at the first 9 months of 2024 versus 2025, there were 21 in the first 9 months of 2024, 21 filings under 1.05, dropped to 11 in the first 9 months of 2025. Far fewer updates, far fewer Corp Fin comments, and less disclosure overall. Probably not because there were fewer cyber incidents, but because folks felt, because of the letter, maybe in the new administration, more comfortable taking the time to make the determinations as to materiality.
And there are a couple of other aspects. I agree with all of that, Olivia. That makes a lot of sense. There are a couple of other aspects of the timing that I think are important to note. The first is there is a narrow delay provision baked into the rule that allows for the delay of the 8K if the Attorney General of the United States makes a determination that the immediate disclosure of the incident, not the incident itself, but the disclosure of the incident, poses national security or public safety risk. I think my first reaction when I read about that and tried to study it is, will that ever actually happen? Like, what are the mechanisms? And DOJ and FBI have put out some guidance on how to follow through with a request for an extension like that. But we do know from tracking the 8Ks that there have been at least 2 8Ks that have had authorized delays by the Department of Justice, one as recently as just a couple of weeks ago. So it's not just a hypothetical. So people, depending on the nature of the public company at issue, the registrant, should be thinking about that issue, even if it may be sort of the narrow exception to the rule. The other aspect of this that's important, it doesn't get a whole lot of play, but it is in the rule, so it's probably worth mentioning, is there is a safe harbor baked into the 8K requirement, which basically says if you file late, if you miss your 4-day deadline, there is a safe harbor that excludes liability for Section 10B or Rule 10b-5 and loss of S3 eligibility if you're late. So the question becomes, particularly in the current enforcement environment, is how does the risk shift? Is it better to take things slow, get it right, and potentially be second-guessed on missing your 4-day clock, or moving fast, trying to get something out, and potentially making a disclosure that could be viewed with the benefit of 20/20 hindsight as inaccurate or potentially misleading? And once you do that, then the potential for liability under the securities fraud provisions of 10B and 10b-5 amplify pretty significantly.
Great. So maybe a final note just on the materiality and timing decision. If you go back to that hypothetical where things just look terrible, systems are down, people are distraught over what this means. Well, let's say the next inject in your tabletop is turns out your CISO and their team had like a really good incident response preparedness plan, and they within 24 hours are able to cut off the systems that were compromised. They have backup systems. By the next day, they're up and running. By the next day after that, website's up, next day. Employees start coming back to work, they can access their email, people have reached out to customers, people are okay, they're going to wait to place their orders, and then the next inject is by the end of the following week, everybody got in the orders that were stuck while the systems were down. Okay, if you had filed the 8K on that first day, how do you feel now a week later? So anyway, good fact pattern to use in tabletops. So with that background, there certainly has been enforcement activity in this area. It goes back years, like the Yahoo case, and at the end of the Gensler administration, there were a number of settlements and actions. As every panel here, I'm sure, we could debate what do we think about settlements from the last administration for this administration, but putting that aside, Haima, can you talk about not necessarily individual cases as much, but like what emerged from that? What were sort of the issues that gave rise to enforcement?
Yeah, I think that what was really interesting that emerged from that, for our purposes today, was really the dissents that were put out by Commissioners Ueda and Peirce to some of those cybersecurity settlements. I think those are important because those might give us a preview of what we can expect from cybersecurity enforcement right now. One area that was unusual under Chair Gensler's SEC was the focus on hypothetical risk disclosures. So the SEC then did charge certain public companies with securities fraud, very serious charge, without an allegation that there was necessarily a material incident. So how it went was the risk disclosures would say something like, we may face a cybersecurity risk, or we may face a cybersecurity threat, we may be breached. When in fact the company had already, like 100% of every company everywhere had faced some kind of cybersecurity threat. I think it caused a lot of surprise and concern that that could be the basis of a securities fraud charge. I don't expect to see those going forward, but I do think those risk disclosure cases were an area where there was some confusion and it was a little unanticipated, again, in the absence of a material cyber incident.
Right. So we don't have a lot of data points yet on cases or decisions in this administration, but just thinking about what the administration has said about its priorities and how it's approaching issues at risk of making predictions, what do the panelists think about, okay, in the current administration, in the current SEC, which very clearly wants to take a different approach than the Gensler SEC, what do we think would be the fact pattern that could give rise to an investigation or even an enforcement case on a public company cyber disclosure? Are there things that we still think would would generate an enforcement interest in an enforcement case?
I think so. I think having a significant material cybersecurity incident and a failure to disclose that is somehow ferreted out, ways that could be ferreted out, it's not just the SEC, a state regulator could ferret out, you could face customer litigation. There's all kinds of ways that can kind of bubble up to the surface, and that's where I think processes are really important. We all remember the famous quote that we shouldn't be second guessing the good faith business judgment of companies on materiality determinations. Well, in some of the hypotheticals we were talking about, I think, John, you said, like, if you have a committee that's supposed to meet and you just don't even hold the meeting so that they can't make the materiality determination, I think that's the type of stuff that's going to look really bad in hindsight.
Great. So Olivia, talking about maybe the leading case of the recent times on this issue, the SolarWinds case, not a recent case. It's been talked about, on the panels last year. I know I have found that court decision, because there are so few, court decisions on big cases on this issue from a regulatory perspective, that court decision still has sort of played a really important role in sort of guiding client decisions on this, and especially because it was a bit of a mixed result, right? The commission got a lot of attention for losing certain claims, but the commission also won some claims, and by one I mean, on motion practice, there certainly wasn't a trial. So Olivia, can you, just based on everything that's public, can you refresh us on, sort of what are the takeaways from that decision, and more than just what was the decision, how has it impacted client decisions and all of us giving advice now?
Yeah, so there was obviously a lot of attention on the case, which I was involved with, as were others in the room, so this is all based on...
I think probably half the room
right, publicly
was
reported.
involved in that case one way or another, either commission,
yes,
individuals.
Well-known litigation. But a lot of attention when it was brought, of course, a lot of controversy, and then the decision, which was last summer, I think it came down the month I left the commission, actually. And a lot of attention to the court's dismissal, of course, of all the claims having to do with the actual filings that SolarWinds made, both before and after the incident disclosure, and also the internal accounting controls charge, which had gotten a lot of attention from many folks in this room and beyond. The court really was not taken up by that claim and did not buy into the theory. But there were parts of the case that survived that I think issuers do need to continue to pay attention to, because an internal accounting controls charge is very interesting to all of us. But I think for the public company and the executive who were charged, still having a 10B claim out there is obviously a very serious and significant matter. So I think that continues to deserve and gets attention from boards and executives. The case is still pending, although the parties did announce several months ago that they'd reached a settlement in principle. It has not been finalized, and of course now maybe a while with the shutdown. But the parts of the case that survived are interesting to look at, I think, for a couple reasons. One is the claim that survived, the fraud claim that survived, did not have to do with a filing. It had to do with statements that were made on the company's website that were directed at customers and not investors. It was a website, I think called the Trust Center. It made statements about the strength of the company's cybersecurity, and the court did not dismiss the claim and really took issue with what was in that statement, which was online for years and publicly available, versus the allegations the SEC put forward about what the company was saying internally. So I think it is, it's a cautionary note as far as looking at statements beyond filings, beyond those that are going to get a lot of scrutiny from folks paying attention to regulatory requirements. And then the other thing, the individual who was charged is now the CISO, remains the CISO, and was the CISO at the time of charging. But at the time of the conduct was not the CISO, I think reported to the person who was the chief information officer. And there was a lot of commentary and criticism, both because of the potential chilling effect, which is one issue to consider, but also because of the person's role at the company, and that they were not, did not have, control necessarily over the statements, did have control over that website statement, but were not, one of the C-suite individuals. And I think the court's decision really, obviously the judge considered everything before the court, but the court really looked at the facts of what the person, what their role was, what their information was, and what their responsibility was for the statement at issue. So title alone did not persuade the court. So I think those are two takeaways out of the mixed bag that was the ruling, where the court rejected a lot of things the SEC put forward, but did buy into those theories of liability that remain things for all of us to grapple with.
Great. And I think it's turned out to be super interesting that the parts of the case that survived, I think to a large extent, were the most controversial parts of the case when it was filed. So I'm sure many people in this room were on calls with panicked CISOs after the case was filed. I'm not a lawyer. I don't know anything about SEC filings. Is the SEC now going to sue me? Do I need insurance? Do I need to quit this job? Of course, we all have weaknesses. What does this mean for my own career? And in particular, that liability, as you said, was premised on not SEC filings. And I find a lot of clients who happily don't have a lot of enforcement experience and need to be reminded that liability is not limited to the statements in SEC filings. I think the furor has died down a bit, in part because there was a lot of attention to the ruling, but those controversial parts of the case survived, and so it's a real reminder, I think, for clients. I don't know if anyone else on the panel has thoughts on the topic, or we could move on to the next.
It's interesting now as we think about the enforcement posture of the current commission vis-a-vis public companies and their disclosures, and the stated focus is typical, but I think even more so now, on individual liability. So you've got this tension. Will the commission go back to a position of not second-guessing, quote-unquote, good faith materiality determinations, especially in the cybersecurity space, but also to the extent individuals are making those determinations, how can you establish and document that good faith so that the CISO or others on disclosure committees or whatnot are essentially in the crosshairs with potential liability?
Right. And in the category of sort of reminders, I think are common now, Haima, one of them has to do with the statute of limitations, right?
So I think it's just the point that the statute of limitations on any of this is going to run longer than the current administration. And so I do think, and I hope you'll all agree, I do think a lot of clients are really trying to implement cybersecurity best practices and disclosure controls that are tailored to their organizations. I think there's so many reasons to continue doing that, to put it positively. But the statute of limitations considerations is certainly one of them.
Right. And the second common reminder I find relevant now is statute of limitations is longer than this administration, and federal government is not the only player on the scene. And so the SEC is not the only player, of course. There's other federal agencies highly relevant to this, and then there's highly relevant state agencies where they may not have changed during the last election. So, GR, do you want to give just sort of some tips on that?
Yeah, absolutely. So, and picking up what Haima said, I think we are seeing more sophistication, fortunately, at issuers and SEC registered entities in terms of having cybersecurity, strong protocols, incident response plans, and the like, which is very helpful when you then are pivoting to addressing the other regulators that might be out there, depending on the nature of the incident that you have suffered. One is the FTC, so you might escape the SEC. Hopefully firm took that beat, company took the beat, figured out exactly what happened, made the right disclosure, the accurate disclosure if one was needed, and you don't have an SEC issue perhaps. But depending on what the nature of the incident was, if you had customer information that was exfiltrated, the FTC may come knocking. And the FTC uses their broad Section 5 power to go after what they consider unfair and deceptive practices. And it's a fairly amorphous standard, but over the years, the last 10, 15, 20 years, they've brought these data breach cases over and over again and they look at the blog posts, they look at the terms of service, they look at the marketing materials for yours, are you protecting customer and client data? And they use that as the hook to say, well, you had this breach and you didn't do a good enough job and you misled your customers. And so that's usually that's only going to be a consent decree and injunctive relief if ultimately charges are brought in the FTC space, but those are 20-year consent decrees by default with the FTC, and that can be a very big consideration for companies. And then there's the states, right? As Rob noted on your checklist, you're looking at materiality. In the back of your head is making sure we sort of get this figured out for FTC purposes, but we also have state notification laws, and they vary by state, right? So if you have customer information that's been exfiltrated, you have to be looking at, okay, well, what states are impacted, what states have customer information been exfiltrated from, and how quickly do I have to notify the state AGs potentially, and then be mindful of potential investigations from the state AGs into their sort of mini FTC authorities under their consumer protection statutes. And then of course on top of all of that, you potentially have plaintiffs bar out there who are going to bring civil suits. And so in the same way in lots of other areas for SEC enforcement, you're balancing perhaps a SEC investigation, private securities class action, maybe parallel criminal. In the cybersecurity realm, you're also, maybe you have securities class action considerations and just private Consumer Protection Act class actions.
Great. So drilling down on two of those last points, first with the states. Haima, can you talk about one leading example of a highly relevant, highly active state regulator, which is the New York Department of Financial Services?
Yeah, New York Department of Financial Services, or DFS, they have a cybersecurity regulation that covers entities under their regulatory purview. So this is financial institutions, insurance companies, banks, just to name a few. The regulation is pretty exhaustive and really requires cybersecurity best practices. So covered entities have to implement cybersecurity policies. So this includes, just as a non-exhaustive list, periodic reports by the CISO to whatever the governing body is of the covered entity, that's often to the board. It requires the governing body to exercise oversight over cybersecurity. That's often board oversight over cybersecurity. They're very similar to what we see under the public company requirements. They have to update incident response plans periodically. They have to conduct trainings, and I've just named like 4 things out of this list of 27 things that they have to do. This year also covered entities had to submit a certificate of compliance. So they either had to say we're complying with your regulations, or here's a notice we're non-compliant, whatever the case may be. I think in a couple of days there will be other parts of this cybersecurity regulation that will kick in, including, importantly, an MFA, multi-factor authentication requirement for the covered entities. Why this matters is that DFS has a really, really broad reach. And for any of us that have had the pleasure of being opposite DFS, they're aggressive, they're formidable, they're tough. And they work closely with the New York Attorney General. And under New York, the Martin Act essentially gives the New York Attorney General nationwide jurisdiction to conduct investigations. So I think this is an area to be really mindful of, just like what JR said. It's, I don't think it's a time to get lax in any focus on cybersecurity just because there may have been leadership changes at the SEC.
And one other player out there, but in a different way, is DOJ and FBI, right? But they have a very different interest oftentimes in these cases, at least on the front end, which is the threat actor, him or herself. And what we've seen is, right, there's a tension between, if a company is the victim of a ransomware attack or an exfiltration and then a ransom demand, is the company wants to get this over with, and they're trying to figure out how to best do that and how to navigate that, and there are pros and cons on different approaches. DOJ and FBI want you to be immediately cooperating with them and working quickly to cooperate with them. And one of the things that the tension you end up then finding is that cooperation can open the firm up potentially to difficulties with the threat actor. And so those are hard conversations that the clients have to take very seriously. The other piece then is, I think it remains to be seen a little bit how much credit you ultimately get when you're talking, whether it's the SEC, FTC, state AGs, and talking to them about, listen, we've done everything right, we've cooperated, we've done X, Y, Z to address this exactly how the criminal authorities want us to address this, and now you're coming after us for X, Y, Z more pounds of flesh. And I think there's a tension there that is, because it's backward looking, because there potentially are, if it's a data breach and customer information, there's an understandable interest on regulators' part to pursue remedies there, but it's not always that cut and dry.
Yeah, and there is sort of a nod to that in going back to the SEC's public company disclosure rules. As John mentioned, there's this exception that you can get from the Department of Justice for disclosure. The other thing is there's some guidance that says, the SEC doesn't expect a disclosure to be like sort of giving a roadmap to the criminals of how to attack their system, which is actually, I think, found to be a very relevant issue when clients are trying to craft an 8K disclosure of a live issue that is happening because of some weakness. And that guidance has been very helpful. Just to round out, one of the points you raised, Olivia, so we talked about the SEC, we've talked about other federal agencies, we've talked about the states. We mentioned, but should spend another couple minutes on private litigation. So I know you've spent time on this type of civil litigation generally, and one type in particular under the FCA. So can you update people on that?
Yeah, there are still reasons why folks need to hire lawyers, defense lawyers. So I would just
the highlight of the panel.
Yes.
Maybe you want to, yeah.
I would touch on both FCA litigation, but also private securities class actions. And in fact, there are 2 circuit court decisions, 3 really, 2 from the Ninth Circuit and 1 from the Fourth, that actually give credence to the risk disclosure, like hypothetical, like that can give rise to liability if you say your risk is hypothetical and actually you've had something come to pass. So that was in the Facebook and the Alphabet cases in the Ninth Circuit, which were not just data privacy, but they were about cybersecurity disclosures as well. And then also in the Marriott decision from the Fourth Circuit, which went for the company, but the court, accepted this theory and just found it didn't apply in the particular case. And, so those theories are out there. They're not just creatures of SEC settlements or orders. They have been accepted by the courts, and they do pose risk and resulted in, 9-figure settlements in a couple of those cases. But then also the DOJ remains, in this administration, very interested in pursuing False Claims Act matters, and began in the last administration an initiative to pursue cyber-related FCA claims by government contractors or against government contractors who have inadequate cybersecurity controls or make misrepresentations. They brought a number of those cases this year, resulting in settlements up to 8 figures. And I think they've more broadly expressed an interest in pursuing FCA cases. So I think that is an area where you're going to continue to see cybersecurity scrutiny from the government. Some of those cases are not, at all straight up fraud. They're very technical about what the government contractor allegedly did not do as far as their controls. And so I think it is something to pay attention to for those issuers and clients of yours who have a part of their business that is a government contractor.
Great. Well, as we wrap up, cybersecurity, as I said, is a hot topic. The enforcement environment, at least at the SEC, that we saw of the prior 4 years is going to be different now. But we don't think it's going away. As GR said, the press release for the new unit, or the refocused unit at the SEC, includes issuer disclosures and other cyber issues in it. States are very active, private plaintiffs are very active. It can be an intimidating area. There's a lot of jargon, there's a lot of technical detail, but there's also a lot of core concepts that a lot of people in this room know well: public company disclosures, disclosure controls, policies and procedures at investment advisors. So it's a great area, and thank you for the panelists, and thanks for everybody for listening.